Okay. Is everyone ready? Like judges, opponents? Yeah. All right, and you guys can hear me good, right? Okay, cool. Um, yeah, so if everyone's ready, I will start my time in 3, 2, 1, go. Hello, judges. My name is Manav, and I am the affirmation first speaker on this resolution that, assuming the choice is necessary, this House prefers to decide on verdicts through a panel of 3 judges as opposed to a jury of one's peers. So I'm going to start off by defining this round as a value round. Our value for this round will be equality, and our value criterion will be societal welfare. Moving on to our first contention, we'd like to, actually, I'm sorry, I forgot to go through definitions. Again, 3 judges is essentially similar to like 3 federal judges in like a court system. You could assume this House to be like the United States federal government's court system. And a jury of one's peers is like a jury of, sorry, let me mute that. A jury of people who are of other citizens who are randomly chosen from jury service in the United States, right? So these are like regular people who are randomly selected to participate in jury service. Moving on to our first contention is that of discriminatory jury selection. So our first claim here is that jury selection is very discriminatory and subject to manipulation. Our first warrant here is that illegal racial discrimination in jury selections remains widespread. And this is according to a recent report by the Equal Justice Initiative that examined practices in 8 southern states. So point A here is that racially biased use of preemptory strikes and illegal racial discrimination in jury selection is widespread, particularly in serious criminal cases and capital cases. In fact, hundreds of people of color called for jury service have been illegally excluded from juries after prosecutors asserted pretextual or basically petty and not true reasons to justify their removal. These reasons include striking African Americans from jury service because they appear to have low intelligence because of their like appearance. For example, certain African American individuals were wearing eyeglasses and they walked in a certain way, or they dyed their hair. And there's countless other reasons that the courts have rubber stamped this as race neutral, right? So what we're seeing here is according to the study, which takes into account like multiple instances from different court cases, they were repeatedly seeing that African Americans in particular were being removed from juries because of their appearance, basically just racial reasons. Some examples of this, I'm going to give you 2 specific examples. One, you can look to the Curtis Flowers trial, which he was charged in 1996 of murder. It was an all-white jury, and the prosecutor during Flowers' trial used all 15 of his preemptory challenges to exclude African Americans from the jury. He used all 15 of his available challenges to make sure that there were no African American in the jury. And the all-white jury in that Flowers trial deliberated for just a few hours following 6 days of testimony before issuing a guilty verdict and a death sentence. They got a quick response even after there was an entire 6 days of evidence, right? These cases normally take like long periods of time to like come to a conclusion with, but it took them just 6 hours. Another example of this, it took them just a few hours. In addition, in Houston County, Alabama, 8 out of 10 African Americans qualified for jury service have been struck by prosecutors from serving on death penalty cases. Another example is in 2010, a white man in Alabama appealed his murder conviction and death sentence after a trial by 11 white jurors and 1 black juror, stating that jury selection was tainted by racial discrimination by including additional black jurors from his jury. And might I add that he actually did get to appeal his case in court again. In a study from the US Department of Justice states that their relationship is evident between the outcome of trial and the personal characteristics of the trial participants in the decisions of jurors. So we can clearly see there's lots of examples. You can constantly refer back to them. Moving on to our impacts, we'll see that weeding out jurors of color can impact the outcome of a trial, either by robbing the jury of valuable perception on identifications across racial lines and policing, or playing into the immeasurable other ways that implicit biases are in our justice system. Second impact here is that research suggests that compared to diverse juries, all white juries tend to spend less time deliberating, make more errors, and consider fewer perspectives. They're also more likely to be pro-death penalty. This is especially harmful for African Americans who are disproportionately affected by these issues. A panel of 3 judges in this case can make more fair decisions, leading to less incarceration and execution among African Americans, and improving the life and economy. And you might be wondering, how are these judges going to make more fair decisions? That's where our second advantage comes in, which is about judges' experience. So our first claim here is that judges are more unbiased than juries. One of the biggest reasons people choose a trial by judge over a jury trial is that judges are not biased and are significantly less inclined to let their emotions affect the outcome of a case. It is their job. They have gone to law school, right? They've spent their entire life putting their feelings aside and learning to look at the facts of the case. Our second claim here is that judges have a full understanding of the law. Unlike most jurors, judges fully understand all technical terms that are used in the courtroom, right? Like even in like debate, right? When we're doing debate, right? Parent judges, who is like a lay person on the jury, sometimes are not familiar with certain terms, right? Like a preponderance of evidence or a statute of limitations. Whereas these judges have like this legal training. And juries actually do not have these legal training, and studies have suggested that legal education of citizens is very much required to reduce confusion about trial procedures. We also see that judge trials are often completed quicker because judges take a significantly less time to reach a decision than juries. This is due to many reasons, but for one, the jury selection process is very time consuming, including strikes, which, as I mentioned, can be very racist. And jurors also require lengthy explanations on various courtroom topics, such as ballistics, toxicology, and many other law terms that are like natural to these judges who have spent their entire life learning about them. And so moving on to some of our other warrants, we'll see that judges as a whole have also been statistically proven to make better decisions. A 2007 study by Northeastern University studying 271 cases in Illinois found that on average, the judge's verdict was at least more likely as correct as the jury's verdict. So it was at least equal, but most of the time it was better. So the impacts here is that we'll see there'll be more fair decision making because unlike juries who are inexperienced with the law and are more likely to be swayed by other less significant factors, judges make decisions largely on fact, which results in fairer decision making. They also stick to judicial consistency, which is really, really important here. The impacts more specifically is that you'll see that there's improved quality of life because there's fewer false incarcerations. You'll also see the economy will improve because people who aren't in jail can be employed and contribute to the economy. So for all these reasons, I strongly urge a affirmation vote. Thank you.
Okay. Really quickly before I begin my speech, just some logistics. For POIs, I'm not looking at the Zoom call, so if you guys have any POIs, just verbally call them out. If I don't hear it, then just say it again until I hear it. And then, so as a quick off-time roadmap, hi everyone, my name is Bhavya Mehta. I'm going to be the first negation speaker, and I'm going to be covering just some quick, like, top of case stuff on the debate. I'm going to be going into definitions, and then we have two disadvantages if you're flowing on paper. It might be like 3 to 4, 5 pages maybe. I'm not sure because I'm on Google Sheets, but it's kind of long. And then I'll be moving on to responding to affirmation case. Cool. Okay. With that, this will be an 8-minute speech, and my time will begin in 3, 2, 1. We strongly negate the resolution that assuming the choice is necessary, this House prefers to decide on verdicts through a panel of 3 judges as opposed to a jury of one's peers. We agree that this is a value round. However, we believe instead of valuing just equality in general, we should value the people of the United States overall. They're kind of similar, but we value the people because democracy is extremely important to the foundations of our country, and democracy kind of plays in with equality. Secondly, we agree that this House should be defined as the United States federal courts. No. Well, we don't agree that this House should be defined as the United States federal court system. We say that this House should be defined as the people because we want to value, again, societal welfare, and we want to value the people. Even if we value equality, the people is a better way to define this House because we're guaranteeing equality for the people. Okay, moving on to our definitions. And so first we're going to define a verdict as usually, like as of now in the status quo, a jury's findings or conclusions on the factual issues presented by a case. And now I'm moving on to some background information. Let's talk about how juries are chosen in the status quo. At trial, one of the first things a prosecutor and defense attorney must do is the selection of jurors for a case. Jurors are selected to listen to the facts of the case and to determine if the defendant committed the crime. 12 jurors are usually randomly selected from the jury pool, which is a list of potential jurors compiled from voter registration records of people living in the federal district. After being in a case, at the end, what the judge does is they give the jury impartial evidence, and then they tell the jury to and then they tell the jury to make their decision. And after the jury goes into deliberation, the process of deciding whether the defendant is guilty or not guilty, no one associated with the trial can contact the jury without the judges and lawyers. If the jury has a question about the law, they write a note to the judge, and then they reach a unanimous decision in order to convict the defendant. Okay, I'm moving on to our first disadvantage, which is going to be on democracy. Subpoint A is going to be on constitutional rights. Judges, the main thing to understand over here is if juries no longer have the right to decide verdicts, there is no point in having a jury because they're not going to have much of a role left in a criminal trial. And one of the most important things about juries is that it is a constitutional right. The Sixth Amendment states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. Basically, what it's saying is that all people are guaranteed the right to a jury trial, meaning the jury has the right to give them a verdict in a specific criminal court case. The Constitution guarantees this. The Seventh Amendment also states that in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. What we see here is that the right to trial by jury, the right to have a verdict passed by the jury, the right to have a jury decide the end verdict of a criminal court case is guaranteed in the Constitution. And if the Constitution, if a constitutional right is overturned, if the verdict is instead handed over to a panel of 3 judges, then we're going against the document that is the very basis of our entire country, of our entire democracy. Why is this wrong? Because this shows that if one part of the Constitution can be turned, then other parts of the Constitution can be turned in the future. It sets a precedent for the future. If that happens, we don't know what could happen. There's no check back. Things could spiral in the future. Other constitutional rights could be taken away, and this hurts the people, and it goes against democracy. The second subpoint is going to be on checks and balances. Checks and balances means that the judicial branch of the government is equal to the other 2 branches, which are the executive and the legislative branch. And the courts can overturn laws or acts of government that violate constitutional rights. Our systems of checks and balances requires a strong judicial branch, and a strong judicial branch requires a healthy jury trial option. Let me talk about why this is important. The subpoint of this is going to be the voice of the people. We count on, normally in our giant legislative system, to count on legislators to propose and pass laws. But without juries, the interpretation of the law would be mainly in the hands of the judges. Juries ensure that the common person has a say in how the justice is brought. A judge does have, say, legal knowledge and training that a normal jury member lacks, but that's why during a trial, the judges act as a guide. They are there to give the jurors any information that they may need help on, and also guide them to evidence that is impartial. The judge may direct the jury to pay special attention to a certain amount of evidence, require answers to certain questions, and even to find a defendant's favor. However, the jury will sometimes say return a verdict contrary to a judge's direction because sometimes the judges are biased. In this way, the jurors act as a checks and balances system inside the judiciary itself. We don't want judges and lawyers making every single important decision because they are not representative of the people of the United States. The juries provide the voice of the common sense and the perspective of the average citizen to our body of law. The second subpoint of checks and balances is going to be on tyranny. The definition of tyranny is oppressive power exerted by the government. Tyranny also exists when absolute power is vested in a single ruler. Jury trials are the opposite of tyranny because the citizens on the jury are given the absolute power to make the final decision. The power is still in the hands of the people. America is a country that is by the people, for the people, and jury trials play into that very role. The checks and balances with the power in the hands of the people ensures that tyranny does not occur and judges don't have tyrannical rule over specific court cases. An analogy to compare this is just to compare this to the US nationwide checks and balances system. The reason we have a judicial branch is to make sure that we check the legislative branch and the executive branch and make sure that those 2 branches don't have tyrannical majority over our entire country. The third subpoint under this contention is going to be on political participation. Serving on a jury is the most direct and impactful way for citizens to connect to the Constitution. It's more active and participatory than voting. Citizens can help perpetuate our system of laws and stabilize our democracy and get their voice heard. A subpoint of this is going to be how we educate jurors about the justice system. My opponents might try to bring up this point about uneducation, how jurors don't know anything. Well, we tell you the jury trials are going to actually help them learn more about the Constitution, because as judges are there, they're going to give them guidance in these cases. They're going to teach them more about the legal system. People who serve on juries just generally have a greater respect for the system when they leave. Serving on a jury gives people insight into the justice system and their own communities and corrects misapprehensions about what takes place better in a courtroom. As they do this, they learn more about the legal system and just society in general, and they become better citizens overall. When they're better citizens, they have better impacts on community, and that leads to a better quality of life in general. Moving on to our second disadvantage, which is going to be on public safety. One specific case example we're going to focus on is product liability cases. A product liability case is when a defendant, or usually a company or some sort of corporation, is liable when the prosecutor proves that a product is defective. When jurors are on a jury trial, what happens is companies are incentivized to make sure their product is as safe as possible because these jurors are the people of the United States that are actually using these products. As modern consumers, jurors encourage safety regulations. Many large companies are now looking to avoid the high cost of litigation and public humiliation. Without the jury system, there's no incentive for companies to add things like safety guards to power saws or to inspect their products for dangerous ingredients. Instead, more and more companies are inspired to spend money on improving the products they produce and the safety measures taken in their production. What does this do? Jury trials encourage and incentivize companies to make products safer, and when products are safer, that's better for the people because they're not going to be getting hurt or possibly like even killed by dangerous chemicals in these products. Moving on to the affirmative case. On their first advantage on discriminatory jury selection, they talk about this example of how Southern states jury selections are biased. Well, to this we have two responses. One, judges can have bias as well. What's to say that a judge doesn't have bias to a specific side or to a specific race in a specific court case, right? Two, there's also a lack of representation in judges. They talk about how there's lack of representation in juries, but let me tell you that that data shows that white judges make up more than 80% of state court judges at all levels of the system. At the highest levels of state courts, state supreme courts, racial minority groups have an even lower level of representation than at the two lower levels, making up only 15.5% of judges. And in fact, they're not even representative of the people. Okay, another thing, they talk about how jury selection can be very slow and can be racist. A recent report that shows that white federal judges are about 4 times more likely to dismiss race discrimination cases outright. Another analysis found that they are half as likely as black federal judges to rule in favor of people alleging racial harassment in the workplace. As you can clearly see, bias also exists in the affirmative world. For all those reasons and more, I urge a strong vote for the negation. Sorry, that was a little overtime.
All right, I'm Ishan. I'll be the second speaker for the affirmative. Just to give you a brief off-time roadmap, my order is going to be negation case in order, and then I'll move on to the affirmative case. So if everyone's ready, I'll go ahead and start my 8 minutes now. So at the top of case, the negation provides an alternative value for this round. They say that we should be valuing the people of the US overall, and they talk about democracy and all. We'll continue to stick with our value. In the end, both of them are similar. Ours is equality, if you remember. Theirs is the people of the US overall. We just believe that this value is a little bit more convoluted, and equalities is a lot easier to define. They talk about how this house should be the people. That also doesn't really make sense because the people can't really be the actor of implementation in this case. It would have to be the federal courts that actually go and change the system to be a panel of 3 judges versus a panel of juries, or about a jury, but this isn't as important. Their definition of verdict is okay, their background is okay, so I'll move on to their first contention, which is that of democracy. They talk about how having a jury is a constitutional right, it's written out in the document. However, if you look at the wording of the resolution, it says it starts off by saying assuming the choice is necessary. This means that as the affirmative team, we're not arguing in favor for the complete abolishment of juries. Nowhere is that listed in the resolution. However, it only says that assuming the choice is absolutely necessary, the House should prefer a panel of 3 judges as opposed to a jury of 1 peers. In reality, jury trials will still exist. So this point about how we're advocating for the dismissal of all juries is just completely false. If you look at the
Yeah.
resolution, you'll see that this is not true. Yeah?
So you say assuming the choice is necessary. Like, can you provide me some sort of example of where the choice would be necessary, just like understand that part a little bit more?
Um, my interpretation was just that the someone involved with the trial, like maybe the defendant would choose. Um, I don't. Yeah. Okay, so moving on. Yeah. I mean, in any case, because it's not like a policy round, we're not doing actual implementation or anything. We're just arguing in terms of value that like judges make better decisions than a jury would. Okay, so moving on, they talk about how a strong judicial bench requires a healthy jury trial. They talk about the voice of the people, and how like juries ensure the voice of the people. However, Judge, one thing you need to remember is that circuit judges are elected by the people. They serve 6-year terms and are elected by county voters on a nonpartisan ballot at general election during even-numbered years. They talk about how judges act as guides to the jury. However, as my partner specifically stated, juries oftentimes cannot understand all of like the legal terminology and other things involved with a trial. Usually, either time is lost explaining to it, and even or explaining that to them, and even after that, they're not going to fully understand everything that's going on in the trial with regards to like specific legal nuances, which judges are much better trained to actually understand. Um, talk about how judges can be biased. They just have no warrants for this. Like, obviously, yeah, judges can be biased. However, we have concrete examples to show you that juries are biased. That more often than not, juries are much more subject to bias on account of both the like implicit um, biases of members of the jury, as well as the practices done by the prosecution to strike out certain members of jury, particularly African Americans, in order to secure a favorable outcome of the trial. They talk about how judges and lawyers aren't representative of the people, and this is an important point because, first of all, as my partner said, in a 2007 study by Northeastern University, a judge's verdict is more likely to be as correct or more correct than the jury's verdict. However, aside from that point, we have to understand that the job of a judge isn't to be representative of the people, it's to interpret the law. At the end of the day, laws are drafted by the legislative branch, right? The legislative branch is the one that's represented by the people. The people elect representatives, congressmen, they draft laws. By that point, the judicial branch is then interpreting the law, and instead of representing the people, they need to be completely separate from popular sentiments. Instead, they need to focus solely on what the law actually says. That's the reason why people don't vote for like the Supreme Court, because if the Supreme Court was like selected by election, then all of a sudden you have this system where the Supreme Court is liable to the people, when in reality that's not what we want. At the end of the day, we don't want judges to be liable to the people. We want them to be liable to the actual law and what the law is written. Representation would still exist because people, if they don't like a law, can like go to their representative, their congressman, and petition for that law to be changed. But until that law is changed, it's the job of the judges to interpret that law and execute it as it exists, regardless of what the people actually think. So in this case, they're not actually meant to be representative of the people. And if they are representative of the people, then we're going to see cases of bias like we see in the southern states that I mentioned, or that my partner mentioned in his first speech. They talk about how like America is a country by the people for the people. Again, people are still going to have control in America, like through voting, and they still have power over the legislative branch. But the point of the judiciary is not to be liable to the people. As I said, it's to interpret the law as it is according to their own training. They talk about how jury service is how people connect to the Constitution and it's more interactive than voting. Um, but again, first of all, judges are elected, and like when you vote for a judge, you're like that's interaction. At that point, it's the judge's job to like interpret the law. Um, and they talk about how jury trials help people learn more, but like first of all, the odds of someone being selected like multiple times for a jury trial is really low, so this education isn't really that valuable. And also, even if this point is true, like the first time that someone goes on jury, when they're learning, as the negation says, that's going to come at the cost of someone's freedom, because even if they come away from the trial with like a greater understanding of the law, they went into the trial with little understanding of the law, meaning that their decision making was based on their limited knowledge, meaning that most likely the verdict was incorrect. Um, on their point about public safety, they talk about companies being incentivized to make good products when they're liable to juries. This argument doesn't really make sense because why would they not be liable if they're being tried by judges? It's pretty much the same thing. There's laws in the country that dictate safety, and if a judge finds that a company's in violation of that law, then of course they're going to sentence them the same way that a jury would. So this argument just really doesn't stand. There's no reason why this doesn't apply to judges alongside juries. So on the AF case, on discrimination, they talk about how judges can have bias as well. Again, they don't really have warrants for this. We give you many warrants about how like juries are a lot more biased than judges can be. We also give you warrants to show that judges are generally better at decision making because they're more educated and all. They talk about how white judges make up 80% of judges, and that shows that like there's bias. However, we can see that in the status quo, this number is decreasing. Nationally, the percentage of judges of color has increased by 2 points since 2019, from 15% to 17%, and the rate at which this is changing is much higher than previous years. As my opponent said, now the number of non-white judges is 20% in the status quo. That's increasing, so we can see that that's improving in the status quo. So judges will be less, like they'll be more representative as time goes on. Additionally, we can see that like 80% of judges are white. Like, yeah, maybe that's true. Again, first of all, it's improving, but secondly, like in a lot of cases, the jury is 100% white, and that's a lot worse because that leads to situations where the jury, after only a few hours of deliberation, decides to impose harsh penalties on the defendant, including most cases execution. And so, essentially, to save people from wrongful execution, incarceration, and to ensure fair juries or to ensure fair trials, you should be voting for the affirmative because at the end of the day, juries simply cannot be trusted with all the discrimination and all the selective bias. They cannot be trusted to make these important decisions. It should instead be in the hands of well-trained and well-versed judges. Thank you.
Give me just 1 second to pull up my timer real quick. Okay. Before I start, I would like to provide a brief off-time roadmap. So I will first be addressing the neg case, aka our case, and then I will be addressing the affs case. And finally, at the end, if time permits, I will actually wait, my bad. I'll start with some top of case stuff and then I'll move on to our case, then their case, and then if time permits, some weighing. Okay, so my time starts in 3, 2, 1. Hi judges, hi opponents. My name is Divya Mohanty and I'm the second opposition speaker on the topic that assuming the choice is necessary, this house prefers to decide on verdicts through a panel of 3 judges as opposed to a jury of one's peers. Okay, so let us start with the negation case, our case. Or sorry, my bad. Let's start with some top of case stuff. They said that on the value mechanism we pose, where we say we would value the people over valuing equality, they said, oh, equality is easier to define. We'd just like to disagree and still stand by our main mechanism on how valuing like good for like people in general and valuing good for democracy is most definitely easier to define than equality, because once again, there's no exact definition for like how are you going to reach this perfect equality. Also, this house, the definition things, we proposed a different definition for this house. We said that we want to define this house as a people because once again, we want to value people and societal welfare as happens in a democracy. And my opponents said people can't be the actor of this implementation. And once again, this isn't a policy round. It says this house prefers. So it's perfectly probable for people to prefer decide the decisions of verdicts happening through a jury over say 3 judges. So this is why we still stand by our definition of this house. Now let me start by addressing the neg case. Okay, so first off, let's start on their refutations to our advantage on constitutional rights. They said, oh, this constitutional right thing shouldn't be a problem because it's assuming the choice is necessary. They're not advocating for complete abolishment, etc., etc. Okay, first off, let's start by addressing something in this round. We are simply out here to prove what would do more harm and what would do more good should this happen. So even if we are looking at assuming the choice is necessary, assuming the choice is necessary, the fact is it would still be unconstitutional. Say we do get to that point, it's still going to be unconstitutional when we get to that point, if we get to that point. So our constitutionality point still stands. It's still relevant because even if it has to do with assuming the choice is necessary, it's still going to be unconstitutional. Also, in answering their POI, my opponents said their interpretation is like the defendant would choose in what situation there would be a panel of 3 judges as opposed to a jury. And judges, I would like you to just think on exactly how biased just this is. Just their answer to our POI, that one side of the case just automatically gets to decide if, say, they don't want a trial by jury, something that is literally constitutional. Okay. So in response to their voice of to our thing of voice of the people, they said that circuit judges are voted in, etc., etc. 1 second, sorry, give me a moment, I'm getting lost. Oh my God. Okay, so they said circuit judges are voted in, and so that's why this is a better choice. See, the fact is, it's better to have citizens directly engaging with the government. But say you buy that circuit judges are still representative of the people. We have told you that in our world that we will have more benefits because, as we tell you, judges guide jurors along these cases. These circuit judges are still going to be there to guide the choices of our jury. So in our world, we have both the people and circuit judges working together to produce the best result for democracy. My opponents try and say that juries often can't understand, that time is lost explaining it to them. But as we say in our case, this time that they say is lost explaining it to them, we argue that no, it isn't lost, because this time that they say is lost is being used to educate the people of our country on judicial systems. Even if, say, maybe they're not part of a jury ever again, they're definitely going to be more aware of the country around them, of the judicial system of the country they live in, and they will be able to, say, make more educated decisions when voting for other people. This is not time lost in any way, shape, or form. This is time gained to educate our people. Okay. And also, once again, as I said, citizens having a direct hand in decisions like this also helps boost democracy, which under our weighing mechanism for all the people, for democracy, this is a good thing. Now, continuing on, they said, oh, judges are elected. This is interaction with the government. Which is more interactive? Jurors getting directly involved in their society through cases, or just electing judges? Because the fact is, a lot of these people, they need this education. This education is good for them, okay? When these judges are elected, often it's just like, oh, I like this judge, maybe they're from my area, I should vote for them. But say these people have been in a jury before, they can be like, okay, this is how the judicial system works. I've been walked through this. Now I know that this judge stands for something that would be good for us. I can vote for them. So decision making, they said decision making based on limited knowledge is the incorrect decision. But the fact is, they're the ones who aren't endorsing knowledge. They say lost time in educating people on the system that they live in, which is just so beyond incorrect. Okay, now let's go on to the affirmatives case. Okay. Let's start by addressing their first advantage on discriminatory jury selection. They said we have no warrants on why judges are biased, when literally in my teammate's case at the end, she talked about how not only is there not proper representation, but white federal judges are about 4 times more likely to dismiss race discriminations outright. This has to do with criminal cases related to police brutality. This has to do with workplace harassment. Another analysis proves that white federal judges are only half as likely as black federal judges to rule in favor of people alleging racial harassment in the workplace. We are literally proving how this is this implicit bias. We have given warrants, we have given statistics. Not to mention, along with that, I would like to just bring up one more statistic on the fact that we're not just looking at race, if we're looking at gender, male judges are also far less understanding and far less likely to rule in favor of sexual harassment cases. And this is a problem because, as we said, female judges are not something that female judges do not comprise anywhere close to as much as male judges in these things. Going back to our representation point, we're also telling you, okay, they talked about how this representation of judges is improving in the status quo, about how it's gone up 2% in 3 years. Okay, first off, 2% in 3 years since 2019 to 2022, if it's gone up 2%, that is really not that much. And also, we're telling you that juries are increasingly becoming improved as well. Heightened awareness of the importance of diverse juries has prompted several federal courts to evaluate selection processes to ensure fair selections. Now, also, I would like to talk about how we're getting rid of implicit juror bias. Successful methods are being implemented in the status quo. These legal system has given warnings to jurors of effects of pre-decisional preferences, which is like implicit bias. And associations, the American Psychology Association suggests that making juries aware of their own mindsets can reduce the effects of cognitive biases by over 45%. We are also solving for this in the status quo. They talk about how, oh, judges are so much more effective because they're professional and they're there to interpret the law, and so they won't have implicit bias. But this is wrong. Look to the example of Roe v. Wade. By the law, Roe v. Wade was an established case that should never have been called into question. But because of severe implicit bias in the beliefs of Supreme Court judges, not only was it called into review, but also there was nothing but belief, and there was no hard evidence that it should be overturned, but it was anyway. So at the end of the day, vote the team that is supporting democracy, vote the team that is doing the best for the people, vote neg. Thank you.
Okay, really quickly before I get my last speech, I'm going to be covering just big neg points that were of classroom debate, and then going over just the aff case, and then waiting. Okay, that is good. My time for a 4-minute speech will begin in 3, 2, 1. We again strongly negate the resolution that, assuming the choice is necessary, this House prefers to decide on verdicts through a panel of 3 judges as opposed to a jury of 1 peers. I want to reiterate that we want to value the people and societal welfare the most in this round. In addition, we also define this House as the people, because if we want to value the people and the societal welfare of the people, then the people are the ones who need to prefer whether they want to decide on verdicts through the panel of 3 judges as opposed to a jury of 1 peers. And we're going to carry with that through our last speech. Okay, there are going to be 3 big reasons why you're going to be voting for negation in this speech. One of the biggest reasons you're going to be voting for us is on our constitution point. The biggest reason why my opponents lose is because of inadequate response to this point. They say that they say that it's actually not going to be unconstitutional because they're only doing it in situations where they're assuming the choice is necessary. There's 3 responses to this that they can't respond to now, or well, that they fail to respond to properly. 1, they fail to define what this choice is exactly. What is a bright line for this choice? How do we decide what this choice is? In a POI, they say, like, the second response to this is going to be like, they say, oh, if the defendant chooses in which situation a panel of 3 judges chooses, or like the jury chooses. That's biased. How can we let one side of the case decide which whether the judges or the jurors are going to choose the verdict of the case? They're just going to choose a side that's going to better help them in that case, right? They have no like proper definition of this. Now say that they don't need this definition anymore. If they don't, if they get rid of the fact that assuming the choice is necessary, then what they're doing is they're abolishing the right of the jury to pass verdict in a trial, which goes against the Constitution. The Constitution is the foundation of our democracy. The 6th and 7th Amendment guarantee the right of trial by jury, the right of verdict by jury. Democracy, and it founds our democracy. If we go against the very document that founds our democracy, we're going against the people, because the Constitution was created for the people. If we go against one part of the Constitution, it can spiral out of control in the future. It sets a precedent for other things in the Constitution to be gone against in the future, and this can lead to people losing rights. There's a high probability of this happening because there's no clear bright line or measurable method of figuring out how to decide when the choice is necessary. The magnitude of this is also large because, as I explained, there's a long-term impact of the Constitution being violated. The second reason you're going to be voting for us is going to be on the voice of the people. The checks and balances system is going to be one of the most important points in this debate. We tell you the juries inside a judicial system ensure that we aren't letting lawyers and judges make all of our decisions. Jurors are direct representatives of the people. My opponents try to tell you the circuit judges are representative of the people by this point, but turn it over to us, because we have people, but we also have these judges guiding these people in these different cases. Checks and balances occurs with the power in the hands of the people for the people, and we ensure that tyranny doesn't occur in our world. The probability of this happening is higher because it's a fact of life that, like, just in general, like in the United States, the nationwide government system is already a checks and balances system, and we can apply that same logic of the judicial branch in different government branches checking each other and balancing each other to this smaller example. Because of this checks and balances, because of the fact that jurors support the checks and balances system, that's why the founding fathers put it in the Constitution, which is why the verdict of the jury is so important. The magnitude of this is that there's going to be no tyranny, and we're also going to be helping represent democracy and leading to a better quality of life for the people. The third reason you're going to be voting for us is going to be on political participation. Serving on a jury is one of the most direct and impactful ways for citizens to connect to the Constitution. My opponents try to tell you how judges are elected, which is still interaction. Which is more interactive? Jurors getting involved in the society, or them electing these judges in these cases? Them getting involved in the cases directly. They're then better citizens overall, and they have better impacts on community, which leads to a better quality of life. Now, the reason you're not going to be voting for my opponent is on representation. We're going to win on the representation point, or we're going to have an equal amount of impact on the representation point, because judges' representation is also basically non-existent. Look back to the statistic where we tell you white judges make up more more than 80% of state court judges at all levels of the system. At higher levels, minorities only represent 15.5%. My opponents try to tell you that they're going to be, this is increasing slowly, but 2% over 3 years is practically nothing. In addition, we also tell you bias still exists, and women and minorities are extremely misrepresented in these cases, which is why we should win on this point, or we should be equal to this point, and my opponents have no points left in this debate, which is why you should be voting for the people, vote for democracy, vote for the side that preserves the rights of the people by the people. For all those reasons and more, I urge a strong vote for the negation.
Okay, so as a brief off-time roadmap, I'll be going over key arguments that my opponents make. Then I'll be going over like voters and then impact calculus. So if everyone is ready, I will start my time in 3, 2, 1, go. Okay, so my opponents start off by saying like they have like 3 big things that they like to talk on. I'd like to now refute some of their key arguments, just reiterating the things that we've said. So my opponents, one of their big points here is that doing this would not be constitutional. But judges, I'd like to reiterate what I've been saying this whole time. We're here to decide which one is better, right? Given this choice, would we rather have 3 judges or would we rather have a jury, right? The whole constitutionality argument is honestly irrelevant because there is no constitutional violation because this choice of jury still exists. We are not abolishing this jury. My opponents keep bringing up this POI where my partner said something. He did clarify afterwards where he said like it's given this choice, right? And we honestly, we don't have to define this choice, right? The resolution is vague. They haven't defined any examples where this choice would not be necessary, right? They haven't provided any of the contrary either. And even if it is unconstitutional, what happens? What is the impact of it being unconstitutional? Their impacts are speculative at best, right? What happens if other parts of the Constitution are questioned? They've never said like, oh, these like 1, 2, 3 things are going to happen if it's unconstitutional here. It's a very low probability impact at best, and it is honestly just irrelevant as well as low magnitude, right? Because it's not going to happen. They also have no response to the fact that judges are not meant to represent the biases of the people, right? The emotional appeal, the other appeals, right? Like the biases that people have, right? Their own lives. They're meant to interpret the laws created by people's representatives. As I said time and time again, right? Judges go through law school, they go through training, they have so much more experience. And my opponents have agreed with this. They've said that they do have more experience and that juries need to go to court to gain this experience, right? I'll say why that's not necessary later, but we can clearly see that the judges are more informed, right? My opponents say that, oh, decisions are better because judges are telling juries what to do. Why are we adding the juries as this middleman, right? We don't need them, right? Judges are better to represent they're better to interpret the laws, right? They said that, as I said earlier, again, we've shown you that judges have been making better decisions. A 2007 study, right, referred to that, how the judge's verdict was at least better than the jury's verdict, right? It was most times like better, but at the very worst, it was equal. And unlike most jurors, judges fully understand all technical terms in the courtroom, right? Refer to that analogy I brought up about even in this debate circuit, right? How there's certain lay judges who, just because they haven't had this like debate education, they don't understand certain terms, right? So it can be harder for them to grasp what's actually happening, right? And so juries do not have this legal training, right? And because of this, contrary to what my opponent's saying, where it would like lead to like better education, first off, what are the impacts of this? What are the quantifiable impacts of like, having this great knowledge, right? What are they going to do with this knowledge, right? In the very low chance that they get elected to jury again, maybe then it has an impact. But this is, again, very low probability, low magnitude impact here. Whereas if someone were to be falsely accused of something, if something was to happen that was bad, right? Like a false decision, that person's entire life is ruined, right? That's a greater magnitude and a much more higher probability number. Another key argument my opponents bring up is that white federal judges are more likely to dismiss racial discrimination outright. Again, refer to my partner said, right? This number is increasing, right? The percentage of judges of color increased 2 points from 2019 from 15% to 17%, and now it's at 20%. What they conveniently ignored is that the rate at which this number is changing has been much higher than it was in previous years. I know this like 2% to 3% jump might not seem like a lot, but compared to previous years, it is significantly more, right? And even, and it's continued to increase, right? This rate of change is continuing to increase, right? And they say that this happens in the world as well, and like women are also discriminated against. Judges, I'm going to urge you not to like weigh this, because even if we have evidence against us, I can't bring this up here. And they also have no warrants. This is all just like women are also maybe potentially discriminated against, right? There's no really facts to back them up. And that's a recurring theme we're seeing throughout their case. So ultimately, the affirmation wins on two big things here. One, on the impact of racial discrimination. As we've said earlier, judges are proven to be biased. We have facts, we have multiple warrants that have no questions, really, they've never refuted them. And it is proven that prosecutors are essentially, we've given you examples like the Curtis Flowers example, the Houston Country example, all of those different things by the United States government Department of Justice, right? We've also seen that juries are inherently biased, right? All white juries tend to spend less time deliberating, make more errors, which is disproportionately harmful for African Americans. Juries also do not have the knowledge that judges have made, right? Ultimately, Judge, why, if it's proven that judges make better decisions than juries, why would we let the juries make these decisions? Ultimately, Judge, we win on our impacts of the economy, because by making fairer decisions, we are keeping more people out of jail and contributing to the economy and death, because a lot of racial justice cases result in death. And for those reasons, I strongly urge a affirmation vote. Thank you.
Great debate, everybody. Alrighty. I think we're going to take a few minutes and make our decisions.
Good debate.
Should we go one by one and give feedback? Or I guess reason for decision.
Yeah, sure. Madeline, you want to start?
Yeah, for sure. Okay. Let me get to my notes. So this was in general a pretty tough round for me to come to a decision on. There were arguments from both teams that I agreed with and disagreed with, but let's just kind of hop into it. So looking at op case, your biggest voter issue came down to the constitutionality of this decision and the consequences of overturning a constitutional right. Essentially, like I was looking at the impacts of setting precedents to overturning others in the future and what that would lead to for the American people. But the place where I think the opposition slipped up on this contention is in their own definition. So the opposition defined this house to be the people. So assuming I buy this definition of it's the people rather than the federal courts, that means, as the Gov is saying, under the resolution, the people are getting the choice, as the resolution says, assuming the choice is necessary. Therefore, they're still getting the option for a trial by jury, upholding their constitutionality and the rights associated with that per the opposition's own definition of what this house is, who the enactor is. So in a world where I buy ops argument on definitions, that I'm going to be siding with government in this particular argument in their response. And if I didn't buy ops definition of this house because it's not a policy round, I am comfortable arguing in a post-fiat world, which the government explains with their second speaker. So opposition's second contention, if for that they brought up in their first speech, I thought got rebutted by government and then dropped by op. So that was crossed from my flow. And then when it came down to checks and balances, I decided that the GUP's argument that judges who have training in being unbiased are more likely to provide accurate assessments than your average citizen on a decision on matters in court. So along with GUP's evidence of cases where extreme racial discrimination occurred in jury cases, evidence that went unargued by the opposition, then I bought the argument that judges who have this training for years and years, as the Gov said, are more likely to make those fair, more educational decisions. And then side note to both teams, I am pretty sure in this tournament we aren't supposed to be citing like specific sources, like it came from this place when presenting information. Not entirely sure that, but that's just something to look into. But anyways, so I gave Gov the win on this debate, but both teams were really, really great, and it was such a fun round to judge. So
Yeah, I can give my argument next. So I voted for op on this, and I did so for I think two main points of clash on the debate. I do want to say that a lot of the argumentation I couldn't buy because of the same reason that Madeline couldn't buy it, which is that there's just a lot of statistics floating around, which, you know, is just not admissible in this tournament by like the policy of the tournament. And so like, for me, a lot of, you know, the Gov one ends up dropping off the board because, you know, it's just a lot of statistics without a lot of link chains backing. So it leads to me coming to two main points of clash that I think decide the debate, which is who leads to less bias, and then secondly, like who ultimately creates like a better judicial system. Firstly, on the bias point, I think the gov point that, you know, judges make better decisions and that judges are or juries are more biased with like white people on them or certain people on them. I can't buy these because there's not a link chain defending them that's independent of the statistics or the studies that y'all cite on gov. But I do think that you access your bias arc on gov through the education point, which I think is also how Madeline said that y'all mainly accessed it. I think it's a fair enough point, but I think the refutation from op that like you're going to have non-representativeness within judges within themselves, and you're going to have internal bias of these judges, like just based on population stuff. I ultimately do buy this and think it's a contributing factor towards like defeating that kind of education thing. And I think especially when op is coming in with, you know, these judges can still be involved in the process, we're just going to have a lot more voices in. I think that ultimately ends up, you know, being the deciding factor on what ends up like, you know, reducing that bias a little bit more. And I think like just having the voice of the people within the court, that op point, it doesn't necessarily get refuted throughout. And I don't think like, you know, voting becomes an effective mechanism for gov to try to mitigate those impacts in this or like, and so I think that, you know, the majority of the argument about who's leading to less bias ultimately swings towards op there. And then briefly into my decision, like I think the second main thing that I considered was whether the constitutional rights argument factored in. I don't really feel like it was super impactful. I think it was a good call by Gov within the member or within the Gov Whip speech to say like, you know, the impacts aren't very tangible and they're not very outlined. For op, if you're going down this slope and going to say that like we're going to dismantle the Constitution here, I need a little bit more of a link chain and a little bit more evidence as to why that's true. And then that can lead you to a little bit more concrete impacts. And for Gov, to be honest, I probably would have just said like we can amend the Constitution or something like that, and then, you know, get rid of that argument right off the bat. But that means that that didn't factor as much into my decision, but it was still a little bit there. I think the primary reason I voted off was for the bias point, though.
Hi, okay. Oh, sorry. Let me start my video. Okay, I've decided with op on this as well. It was a really well debated and a very difficult decision. This is the first time I'm judging, so having the kind of like top of case and definitional issues was, you know, made it particularly challenging for me. However, I was persuaded by op's arguments that having a jury of one's peers would be better for the people in general, in society in general. And I was not necessarily persuaded by the constitutional arguments, but the arguments related to the voice of the people and preventing tyranny were very persuasive. And, you know, though I tried to look at this to see if going with the definitions of government that government provided would change the decision. And in that regard, I felt like the main contention regarding the bias in juries was successfully like refuted by the existence by op's arguments that judges themselves are biased and do not fully represent the population. So yeah, so based on that, I decided with op, but you both did an excellent job, and it was a really difficult decision.
Thank you. Good round.
Thank you. Good debate.
Thank you.
Great job.
Thank you. Yeah, good luck in the rest of your rounds.
Good luck,
Thank
y'all.
you.